The U.S. Supreme Court has announced that it will review Trump's claim of presidential immunity after a lower court ruled against him. This decision will cause a delay that could either extend the D.C. criminal trial over Trump's efforts to overturn the 2020 election until late into the 2024 presidential election or completely derail the case. The Supreme Court could have rejected Trump's appeal without hearing arguments, but instead, it has scheduled oral arguments for the week of April 22. Even if the justices reach a speedy decision in early May, the trial would be postponed until at least midsummer. This delay aligns with Trump's legal strategy of trying to postpone his criminal trials. But before we continue, please use some time to like this video and hit the subscribe button. The Supreme Court will examine whether a former president enjoys immunity from criminal prosecution for actions alleged to have occurred during their tenure. Lower court judges have unanimously ruled against Trump, expressing strong criticism of his arguments. It is widely expected that the conservative majority of the Supreme Court will agree with these rulings. The main concern is the timeline. The D.C. trial is on hold until the Supreme Court issues a ruling. Based on calculations, even with a rapid decision in early May, the trial may not be ready until August. However, if the Supreme Court does not issue a decision until early July, it would likely prevent the trial from happening before the election. The trial is expected to last at least a month, and it is uncertain whether the unofficial, 60-day rule against bringing politically charged cases close to an election, which is followed by the U.S. Department of Justice, applies in this situation. If Trump wins the election, he would have enough executive authority to make the case disappear. The Republican National Convention, where Trump is likely to be nominated as the GOP presidential candidate, is scheduled for July 15 to 18. The election itself will take place on November 5. If the trial proceeds, it would fall between those dates, but there is a possibility that it may not happen at all. In a separate matter, a judge denied a request from Trump's attorneys to post a bond of only $100 million out of the more than $450 million he owes from the verdict in his New York business fraud trial. However, the judge lifted the penalty that would prevent Trump from applying for loans from New York banks to cover the bond. Trump's attorneys claimed that he does not have enough cash to cover the full amount and suggested that he may need to sell some of his real estate properties to raise the money. Trump has until late March to secure a stay that would pause the accumulation of interest on his debt while he appeals. Trump would automatically receive a stay if he provides money, assets, such as his New York real estate, or an appeal bond to cover what he owes. The appeals court could also grant a stay with a bond for a lower amount, which Trump's team is now requesting. Two significant hearings scheduled for Friday will play a crucial role in determining the future of two of Trump's main criminal cases. In Trump's Florida classified documents case, a hearing will be held to consider deadlines that could delay the proposed trial date. In Trump's Georgia criminal election interference case, a hearing will address whether certain individuals involved in the case should be allowed to remain, considering concerns about conflicts of interest. If they are removed, it could completely disrupt the prosecution. In Trump's pending New York hush money criminal trial, prosecutors have requested a gag order to prevent Trump from attacking potential witnesses and others involved in the case. The gag order would exclude the prosecutor and the judge from its scope. Judge Arthur Engoron, who presided over Trump's New York business fraud civil trial, received an envelope containing white powder, prompting an emergency response. Donald Trump Jr. also received an envelope containing a death threat and white powder earlier in the week. Wisconsin's bipartisan State Ethics Commission has recommended felony charges against Trump's Save America Joint Fundraising Committee for allegedly attempting to circumvent campaign finance limits in an effort to defeat a critical Trump opponent in a primary. The U.S. Supreme Court has yet to release an opinion on whether Colorado courts were justified in barring Trump from appearing as a candidate under the 14th Amendment of the U.S. Constitution. It is unlikely that a ruling will be issued before Colorado's Republican presidential primary next week. During oral arguments, the court's justices strongly indicated that they were likely to overturn the Colorado court's decision, which is currently on hold, allowing Trump to remain on the ballot. Former White House Chief of Staff Mark Meadows' attempt to move his criminal charges from Georgia to federal court was denied by the 11th Circuit of Appeals. His last option is to appeal to the U.S. Supreme Court. Former White House advisor Peter Navarro filed an emergency motion to delay the start of his prison sentence after being convicted of contempt of Congress. He is expected to begin serving his sentence soon. Former Justice Department lawyer Jeff Clark, who faces disbarment from the D.C. bar, lost his bid to prevent other Trump administration officials from testifying in the proceedings. The disciplinary panel of the Bar Association determined that executive privilege does not apply in this case. Thank you for watching. Before you go, please leave your thoughts in the comments section, subscribe, and stay tuned for more updates.